I'm Rodger Citron, and I'm a professor at Toro Law Center. This is a Toro Law Review podcast, and today, this one is for all you first-year law students. We'll be talking about civil procedure. Um, with me today are my Toro Law professor colleagues, Laura Dooley and John Quinn, and we're going to be talking about a recent Supreme Court decision on subject matter jurisdiction. Try not to get too excited. We're going to get kind of excited, but that's your first sort of warning, trigger warning about what may happen in the podcast to ensue. The case is Royal Canin U.S.A. Incorporated versus Wullschleger. It was decided in January of this year, in January of 2025. It was a unanimous decision written by Justice Kagan. And let me start by having my fellow colleagues, my fellow podcasters, say a bit about themselves. Laura, if you'd like to go first.
I would. I thought you were going to say my fellow Civ Pro nerds because I think we're all
Yes.
self-described that way. Yeah, so I'm Laura Dooley. I teach at Turo Law, and I have been teaching civil procedure for more years than I care to share, but let's just say 3 decades plus. And I am fascinated by the machinations of the litigants, given the rules, sort of the three-dimensional chess aspect of jurisdictional rules. And of course, I just as a sort of a fundamental thing, what we see happening in this case is what happens, I think, a lot, which is the jockeying for federal jurisdiction by defendants and knowing that the decisions made by plaintiffs to try to keep cases in state court. So that's sort of the underlying motivations for both sides that drive their procedural decisions. So with that, I'll
John, uh,
So,
tell us
uh,
a little bit about yourself and then.
so we have a very balanced podcast because I'm fairly new to the teaching. I'm brand new to the teaching at the formal level of civil procedure, although I've lived the subject probably for the same length of time as Professor Dooley's been teaching it. Uh, I share her vocabulary. I would call us civil procedure nerds or proceduralists. I like that word. Uh, my my POV, for lack of a better word, in shorthand, is I would call myself a jurisdictional purist. Absolutely, it's one of the few questions for me in the law that is not a maybe proposition. Jurisdiction exists or it does not exist. Yes or no. And you can say that about very few things in the law. So it's another reason I like the subject. And I share excitement when a new case comes down that we know is casebook bound. I tell my students, I remember being in civil procedure in the spring when Matsushita versus Zenith came down and we were doing summary judgment. And, I was in the courthouse when Twombly came down. And so I feel that kind of excitement with this decision. So
Yeah, and I just want to make sure when you say you were in the courthouse, I think this is something that certainly is relevant. Can you talk a little bit about your experience as a law clerk? And
So yeah, briefly. So it's a job most people do a year out of law school. I did a very unusual thing. I was a law clerk to a federal judge as a mid-year position for a span of 15 years. So I had a hand in what judges do, probably to a greater degree than just a one-year clerkship would have afforded. And so jurisdiction was a sacred subject to us. Absolutely.
let's turn to the case. I say this so often to students, I don't get to say it so often to fellow professors. But I'm going to go back to you, John, and Laura. You can supplement as appropriate. Can you get us grounded or oriented by describing the facts of the case and how we ended up in the Supreme Court with this particular case.
You're cold calling me. Oh my goodness. Well, I will start with how it's laid out a little more thoroughly in the Eighth Circuit. Anastasia Wullschleger, if I can say the name correctly, had a dog with health problems, and she was getting a food for him that required a prescription, and so she brought this, and her claim was, oh, getting a prescription made me think there was some kind of medicine in this food, when in fact it wasn't. It was just food. So she brought a claim under the Missouri Merchandising Practices Act, claiming that this was deceptive. She sues Royal Canin, Nestle Purina, big corporations. They removed to federal court. And their theory was not that she asserted per se a federal claim, but that there were federal ingredients in her claim that required an explication of federal law. The idea of unlawful parallel conduct was embedded in it, and they removed. And initially, the district court remanded. That was then appealed. The remand was upheld. And then the plaintiff said, I don't want to be in federal court. So she amended her complaint, FRCP 15, the rule we learned about, and we're not quite so sure how important it is. And to quote from the Eighth Circuit opinion, she eliminated every reference to federal law in the complaint, cut the antitrust claim, and narrowed her request for injunctive relief. And the district court thought that those changes didn't make a difference, and thought that federal question jurisdiction still existed, essentially relying on what got it there in the first place. So the theory is that changes made once the removal occurred did not strip the court of jurisdiction. The Eighth Circuit disagreed, wrote a version of, we're going to use the term a primer, sort of a lesson on jurisdiction, and said, no, it's not, that there's no federal component left to the case. It doesn't belong here, right? Supplemental jurisdiction, all these concepts we learn about, there's nothing to which it is supplemented. She eliminated the federal claim. And the Supreme Court took the case. It's a very important issue. Unanimous opinion, and wrote what we think will be a decision in your casebook someday, saying there's no federal component to the case. There's no federal jurisdiction. So that's just to get us started. There's much more to say.
Yes, thank you. And it's especially helpful to have the full procedural history in the lower courts before turning to the Supreme Court decision. Laura, anything you want to add to John's summary?
Wonderful summary. I will just add that you might wonder, well, if for once the Supreme Court can decide unanimously on a procedural result, why did it even end up in the U.S. Supreme Court? There had been a circuit split. There was problematic language in a previous opinion that the defendants who wanted to be in federal court seized on as authority for why the federal jurisdiction once established should stick, even past an amended complaint that gets rid of the federal claims. So the Supreme Court takes the case to say, nope, there's nothing, as John said, there's no federal anchor for which the state law claims can tether their boats. If there's no federal anchor to which you can tether your boat, then there's no federal jurisdiction. And not only should the case be remanded, it must be remanded. So that's
No, very helpful. And just to clarify, you were talking about a circuit split that was inspired by language, which we now know is dicta from prior Supreme Court decision or decisions, depending upon how you count the two cases discussed in the last part of the Supreme Court's decision. now that we have the case in front of us, there's, well, John, I'll go back to you because you said we're talking about a case that will be in our students' case books, certainly in the fall in the supplements, and then subsequently, of course, in the volumes themselves. Um, how would you use this case in teaching subject matter jurisdiction?
Well, so thank you for the question, Roger. This case makes clear that removal jurisdiction does not have different rules, right? This is the great equalizer. So, I mean, that was the way I understand what the courts disagreed about that led the Supreme Court to taking it is whether something that changes. So we start in original jurisdiction. You measure it at the time you file your complaint, right? And so on removal, if you had it to get in the door, but then things change, should it be the same rule as happens in an original case? And the Supreme Court is pretty much saying yes, that it's not as if removal, and it goes back to the black letter rule that the basis for removal is identical to the basis for bringing the lawsuit in the first place. So removal jurisdiction and original jurisdiction have identical standards. Even though there's been this removal step, we don't have a softer, lesser standard for jurisdiction. And again, that's why, back to my opening remarks, jurisdiction is always an absolute yes or no. There's no in-between time where we can be uncertain and let the case pend, right? And although it's not the heart of the opinion, thank goodness 1447 is mentioned. If at any time, right, after removal, it becomes apparent that the court lacks jurisdiction, it shall remand, right? And so, students in the second half of the course, right, we're focusing on Rule 12 motions, and why is subject matter jurisdiction the only one that is never waived, can be brought up, in theory, until the moment the verdict comes in, or even later if we look back and we say we misapprehended or misapplied jurisdictional law. This is a nullity. So the lack of bend, I think that's just it. It reinforces the black letter nature of jurisdiction as a proposition and as a concept that has to exist for the court's words to have any meaning. In other words, we can't just dismiss on 12b-6. We have to dismiss because we have no jurisdiction to dismiss on 12b-6. And that's the message here.
Yes. Yes. What you're talking about, sometimes I think of that as a symmetry point.
The symmetry point. Exactly.
And Laura and I yesterday were on the Long Island Railroad talking in a very animated fashion about
time work gets done. We think
well, let's just say that the other passengers in the car don't need to listen to the podcast, but they might want to as a refresher. But we were talking about the idea of there's at least one way of thinking about the case is saying, well, there's an easy part to the case, and I think that's what John has, we would say, restated, and then there's an additional part to the case, and
I might substitute.
Yeah, so
You're right.
take it from there.
Yeah, I was just going to say that we did call it the sort of easy, John referred to black letter, or I like John's framing of it as the purist view, or the absolutist view of jurisdiction. And because I think that brings into sharp relief what really matters as a federalism principle here, right, is that the federal courts are courts of limited jurisdiction, limited ultimately by Article 3 of the U.S. Constitution. And not having like I said before, an anchor, a reason to be in federal court means you can't be in federal court. It's just that straightforward and simple. And it's a sovereignty issue. It's because for the feds to take power, even if it's, more convenient, even if the parties want it to be there, both of them, doesn't matter because it infringes on the sovereignty of the states. And that's the background principle, foundational principle that informs all of it. And I agree, that's the purest and by far the most important takeaway from the case. So in terms of using it in class, it does set that out in I think quite straightforward prose that Justice Kagan sort of lays that all out. So now do we go to the more the
Yeah,
permutations of it?
and the only thing I want to add to that is um, the whether we call it symmetry or coextensive, which is another way I referred to it in class. What I thought of when we were talking yesterday of being easy about the case in terms of understanding it is that in the same way that under 28 U.S.C. 1331, federal question or arising under jurisdiction, right? That for there to be original subject matter jurisdiction, you must satisfy, the standards for arising under jurisdiction under Motley and subsequent cases, right? That there's a federal question. That means that there is that the claim arises under federal law. There's some subtlety or additional wrinkles to it, which are actually, of course, part of the procedural history of the case before the Supreme Court, this federal ingredient point. But if you allow me to simplify, when we jump from original subject matter jurisdiction to removal, the symmetry or coextensive point is that a case that could have been brought in federal court originally, if that case is brought in state court, there is an absolutely equal ability to remove or coextensive ability for the defendant to remove when we are talking about the federal question jurisdiction. So now we sort of turn to, I think, other discussion in the case. And I'll go back to you, Laura, to say a bit more.
Yeah, one thing that appealed to me, and I think I should probably reveal my bias if it doesn't become obvious. I'm always interested in access to justice. And if the paradigm situation is sort of little guy plaintiff versus big corporate defendant, this is a case like that, right? This is a consumer case against, as John said earlier, big corporate defendant. And when the court talks about the plaintiff being master of the claim, right? That's sort of a shibboleth. We've had that in the vocabulary, in the vernacular forever. But there are lots of ways in which it's not really true because, as Dean Citron just mentioned, the defendants have procedural tools available to them as well to control the forum. And so I think to me, another message of the case is that a plaintiff willing to delete all references to federal law, even those that, in my opinion, should not have made the case subject to removal anyway, because they were really tort law claims with federal ingredients, so that's a whole different subject. But putting that aside, if a plaintiff is willing to forego all their federal claims because they care about being in the state forum and state law gives them an adequate remedy, so be it. That's the plaintiff's decision, and it should not be overridden by this procedural move on the part of the defendants.
Yeah, yeah. Does anyone want to talk about diversity jurisdiction?
Well, yeah, to me, that's the hard part. I don't know. Can I say that after a lifetime in federal practice in the federal courts, I'm still not quite sure where I stand on diversity. I'd like to go on a limb and almost predict that this decision may open the door to some of those, to some greater uniformity in those, because it speaks so clearly about the parallel between original and removal for arising under purposes, and it's allowing, it's almost like closing the door. Well, we're going to leave that room a mess for right now, right? Because diversity is like, I think the other critical piece of this is it sort of ennobles amended pleadings. It reminds us that they completely supersede. I can't find the language, right? Sort of renders the earlier one a nullity, and it steps up to the front of the line, and it's the pleading. And but diversity hasn't completely caught up. I mean, like you sue in diversity, and then what if one of the parties moves? Like I was thinking how, like, Rule 11 is not going to require me to amend my complaint to now account for the fact that we're not diverse. And yet the case can stay. Like, doesn't that already trouble you in light of this opinion? In the light of my own earlier words, I almost should take some of them back because it speaks so absolutely, but it didn't cover the subject of subject matter jurisdiction as completely as a purist would like, because it's acknowledging how the rules play out differently. I don't think this facts on the ground, facts alleged thing holds water in the end. I think I was trying to picture how I would try to teach it. The Eighth Circuit decision is completely premised on facts on the ground, facts alleged. I don't know if it survives true rigor when you look at it, but the amount in controversy, right? We rely on what's the good faith allegation, right? What if the amount? My students ask me, well, what if we talked about remediator the other day, right? Well, what if the complaint comes in? What if the verdict comes in and it's less? Does that mean the whole trial was a nullity? Does that prove we didn't have jurisdiction? A purist in me says maybe not, right? Or the parties move around. Why can we, if I add formally an indispensable non-diverse party, and then I've destroyed jurisdiction. So there are still imperfections, and I could see this case leading to another case that says, given the purity with which this decision speaks of jurisdiction, we need to clean up the mess on the diversity side.
Yeah,
Well,
and that's, yeah.
go ahead, Laura.
Yes.
'Cause
Yeah, a couple things. One is that this is not original to me. One of our Civ Pro colleagues in another school on the listserv talked about whether there's a distinction to be made, and I'm going to use your term purity, for the purity of constitutional constraints on federal jurisdiction versus statutory constraints on federal jurisdiction. So all that stuff with diversity is statutory, right? All Article 3 says is between citizens of different states. So one could argue in theory that as long as there was diversity between citizens of different states, minimal or otherwise, at some point in the litigation, the Constitution is satisfied. That doesn't fix the problem because we still have these statutory constraints that matter. But the amount in controversy is a perfect example. 1332 gives you an amount in controversy, and it says if the plaintiff ultimately doesn't recover that amount, plaintiff may be charged costs. So there's an incentive built in not to manipulate that to get federal jurisdiction, but it's certainly not absolute in the same way that we think about federal question jurisdiction being absolute. And I think this constitutional versus statutory distinction is helpful in that regard.
I mean, I very much appreciate it. I think of long arm versus minimum contacts. I mean, we always have that gap, right? There's always that. I don't know if the students appreciate it as much. Like I still, obviously there's always almost an asterisk for me when we speak of diversity, right? Because it just seems less compelling as a constitutional reason as any reason, right?
Totally.
Right. I mean, we all know that. We don't have to finish that. And so it's just strange to me that there's still you can relocate after the lawsuit begins,
Right.
know,
And
because I
it
think
doesn't deprive the court of
that
jurisdiction.
there's
Yeah.
in terms of purity, there's a temporal purity. There's sort of a temporal requirement in what this court is, what Justice Kagan authored for the court, is saying about jurisdiction, that it can exist and then can no longer exist because of subsequent things you do with your pleading. Now, I don't know why that counts more than the facts on the ground, which is the party moved across state lines.
Yeah.
Like,
Yeah.
and then do we interrogate the intention of the relocation? Isn't that arguably manipulating diversity to set up the lawsuit and then change and amount of controversy? So I see that as a mess. I hope it gets cleaned up.
Yeah, yeah. And I guess my comment, substantive comment, uh, is that there was, going back to the comments on the civil procedure listserv with other professors, there's forgive the expression, diversity of views on what people thought of the court's opinion. Some were critical, some were complimentary, and I lean towards the complimentary side of the spectrum insofar as um, I feel like Justice Kagan is doing no more than reflecting the idiosyncrasies of diversity jurisdiction, which have different levels to them. Because, of course, Laura mentioned Article 3 in the Constitution. There's different statutes authorizing federal jurisdiction. And then, of course, there's case law, which interprets those statutes. And where I want to sort of segue to is if you were a justice, very seriously, if you were a justice, you don't have to say anything about diversity jurisdiction to decide this case.
Right.
Would you have just, would you have said, let's write a 5-page per curiam opinion resolving the circuit split in which we say the prior Supreme Court cases discussed in the last section of the opinion were dicta, and all we're doing now is making it clear that they're dicta that shouldn't be followed. So let me ask the question about, as we sort of, you know, uh, move from diversity jurisdiction to the opinion itself and how it was written, if you have thoughts about that. Um, I'm gonna go to Laura because I know that I'm gonna go to Laura and then I'll go to John. Yeah.
Sure.
Yeah. So, two things. One is, and now I have to give credit to our con law colleague, Professor Roy, because I was having a conversation with him just about Supreme Court behavior in recent years. And I realized that this opinion is a little bit of an example of it, because it had to respond to the dicta from a previous case that seemed to go the other way. And they do that by pretty much saying, yeah, we didn't mean that. It was, as I call it, a drive-by jurisdictional statement.
Oh, best line.
That drive-by, I know, the drive-by. And Professor Roy, I think, has observed that this is happening more and more, that the Supreme Court, this current configuration of the Supreme Court, is issuing opinions in which they decide what they need to decide, but then they throw out a whole lot of other stuff, what we call dicta, that comes back to bite them later, and they have to clean up the mess that they themselves created. Those are my words, not his. I'm not putting words in his mouth, but I think this is an example of that. Why was that footnote in the other opinion? It wasn't relevant to the other opinion. It wasn't, which is why they're able to distinguish it now. It's so it's kind of
Can I just pause or to interrupt? Only to note that in the Rockwell case, and this really is so perfect because I was looking at it right before we did the podcast. It's a majority opinion written by Justice Scalia. There's a dissent by Justice Stevens. And I say that only because one of the discussions we're having is, so how should justices write their decisions? Or that's what we're talking about. And of course, they had very different views. That Scalia was We're here to
Right.
articulate rules. And Stevens was more of a common law judge or justice. And no, we're here to decide cases. We'll figure out the next case when it comes to us. We don't have to decide that one or articulate rules in advance. So I thought that was just perfect in
Yeah,
light of
absolutely.
your
Well,
comments as well as what we're talking about now. I
yeah,
know I
absolutely.
interrupted. Do you want to finish?
No, sorry that I just interrupted you. Sorry about that. But yeah, and if the Civ Pro students that might be listening to this want another example of Justice Stevens being the pragmatist that wants to just decide the case. Remember the Burnham case and the big fight between Scalia and Brennan about why jurisdiction exists in California over a person served with process in California.
Personal jurisdiction.
It's a personal jurisdiction case. And it's really a jurisprudential battle about whether the Constitution is fixed in time and whether it is evolving. And Stevens says, we don't need to fight that fight when we all agree on the outcome. And so it is an argument, I think, for that sort of jurisprudence that Justice Stevens embodied, that why bite off more than we need to chew for this case, because it can and does create problems in later cases. So I agree with that, and I'm curious what Professor Quinn thinks.
John,
Well,
we're on pins and needles here. Tell us, what do
no,
you
no, no.
think?
So you did a level more research. So you're saying the footnote was authored by Scalia?
Yes.
So, I mean,
Yes. In the Rockwell case.
you're not
Yes.
suggesting there's any sort of ad hominem stuff going on here. I mean, I read on, the admonition goes double for throwaway footnotes about jurisdictional issues neither raised in nor conceivably relevant to a case. It seems like a bit of a reprimand to me,
And that was true in Burnham too. They really snipped at
right?
each other.
I
And
mean,
so
you know,
what's the underlying thing here? Like, what are they really mad about? Can't be this.
I love I agree with the way you frame that there's sort of two approaches to judicial opinion writing. You know, the more narrower deciding the case, which is really more of a district court minded thing. I mean, my years in the district court, you know, our job is not to make the law. What is the Second Circuit rule on this? I don't want to make law, right? Whereas the higher up the courts go, Second Circuit, we want to speak broadly. Certainly, the Supreme Court always knows it's speaking with a broad brush, although they often opt not to, right? And they want to, purposefully remain divine-like in their mysterious ways. But this, after the throwaway, the drive-by jurisdictional ruling, this is a reprimand if I've ever seen one. The admonition was neither raised in nor conceivably relevant to a case. We therefore need not follow the Rockwell footnote just because it exists. Our adherence instead depends on whether it withstands analysis. I mean, I'd love to show students that the Supreme Court consists of 9 human beings with opinions about lots of things other than the issue in the case. And they play out. And in a way, more look at this, I'm surprised it's unanimous.
Right, right.
Right? Can't you see a justice saying, "Well, do we really need that dig against Scalia?"
I can't imagine a justice saying that. Absolutely, yeah.
But I'm not going to hold. I won't refuse to sign on the basis of it. But that's beyond primer material. Well
Right,
beyond primer material.
right.
Yeah. Well,
Right. I like that you brought it up, Steve Citron.
thank you. And I think slightly more not sympathetic, but I in the sense of I think that the way that footnote is written, it led a number of circuits to believe it does matter whether it's original subject matter jurisdiction or removal. And so that is, I think that the admonition is really directed at the substance as opposed to the author. And we can speculate as to that, but that's my own view. Let me say that we've actually for a case that was decided unanimously. We've talked for a fair amount. Let me ask, is there anything else that
Yes.
you'd like to talk about for
So
the
I can,
benefit? Yeah,
both of us raised
Laura,
our hands.
yes, I hope I hope we show the recording because you properly raised your hand.
Did you want to go first?
No.
Oh, okay. All right.
You hit your button. You hit your button first. I didn't
I
even
hit
hit
my
my
button
button.
and then, okay. It's like in Jeopardy. Yeah. What is the amendment rule? Okay. So I did want to go back and talk about Rule 15 with regard uh, to this. And, I earlier revealed my pro-plaintiff bias and my feeling that plaintiff is and should be the master of the plaintiff's complaint. Having said that, can you imagine a situation where a district judge might balk at the following plaintiff strategy? So imagine a plaintiff files their case in state court, including federal and state claims, no diversity, federal and state claims. Defendant removes. And plaintiff thinks, well, let me tip my toe or dip my toe in this pool and see how it goes. So plaintiff participates in pre-trial proceedings, maybe even some discovery, doesn't like how it's going, then files an amended complaint, deleting the federal claims. The purist in us would say it still has to be remanded at that point, right? Or could you imagine a district judge saying under Rule 15A, because the time for amendment has passed, time for amendment without permission has passed. Can you imagine a district judge saying that even though leave shall be given when justice so requires, this would be unjust to allow the leave to amend because it would validate or enable this plaintiff strategy of sort of testing the waters in federal court?
Yes. Or we talked
Or
about this.
no.
Right. Well, I agree. There's two possible answers, and I think we just covered both. But let me say that and you've exactly sort of framed it in the right way. I think there's this, haven't fully researched it, but there's this idea that is having that is in effect litigated, which in effect means you could see it as a form of consent or waiver through litigating in the federal court. That is that now that would seem to be gamesmanship insofar as uh, the references that you're deleting, whether it's references or actually claims that you're deleting, um, uh, seem to be done with the intent to not only forum shop, but that is to forum shop, that is to return the merchandise
Mhm.
um, as part of the shopping experience. And yet, if we are in a binary world of yes or no, um,
Right.
well, this is one for us to keep an eye for,
Yeah.
or eye out for. John.
Well, so Professor Dooley, I mean, I love your hypothetical. I guess that's a missing piece of this decision, which is we're not examining the did justice so require the amendment, right? Let's say you're outside the window,
Yeah.
and unless I'm misreading, I mean, I also felt like sort of a missing piece in this, or what this is not a counterclaim case, right? This is removal, and you sort of wonder why didn't they why didn't they why didn't they just counterclaim, right?
And they get a hook. Yeah.
And it's funny, we had just done 41, so Rule 41 in my class, a little bit out of turn. I think of the provision there. What the plaintiff was doing in this case is very much Rule 41-ish, right? I'm voluntarily dismissing,
Right.
right? And if I'm not in the super short window, the 15A like window, then I need court's approval. And there's that provision in 41 for court order that on terms that are just. However, if a defendant has pleaded a counterclaim, the action may be dismissed over the defendant's objection only if the counterclaim can remain pending for independent adjudication. And even in my effort to kind of get through some stuff quickly about the rule and not go back to jurisdiction, that's the cloud over that rule, right?
Right, absolutely.
What could that survive if it was just a state claim? And of course, the cases depends how far along it went, and it sort of sounds like discretionary federal jurisdiction, which doesn't comport with this.
Purity.
But I thought of this plaintiff throughout as this is sort of Rule 41 kind of activity, right? And I think it's perfectly okay. So just another thing, I'm correct. I'm just sharing what my POV is on this. I say plaintiffs get to control as much as they want. They brought the lawsuit. Rule 41, they can even say don't want it anymore. I do think once, to use the old term, once issue has been joined, right? Once the defendant is in the ring, right? Rule 12, you're not in the ring. I'm in denial. This case shouldn't happen. I'm in the ring now, right? Once that's happened, I do appreciate the considerations, the balance changes. Going back to my time with the court, our approach, if there was a way to get a case off the docket, we're not going to make it stay. Like there's no compulsion. We're not going to coerce you into making the jurisdictional choice, the jurisdiction granting choice of your claims and actions. So I think forum shopping has a pejorative tone. I think it's a perfectly neutral activity, and it's a perfectly appropriate thing that the rules invite litigants to do in this adversarial system.
Absolutely.
It's a V in the middle, right? We're not in. And
That's
so,
right.
yeah, what's your move? What's your next move?
Right,
And
exactly.
I always think if the rules authorize it, it's a legitimate rule. And even
Right.
if taking the move tests the limits of the rule, that's a good move too.
It's zealous advocacy.
Right?
Yeah. So
No,
Boy,
this
are
is
we proceduralists.
we are. I think we can say it. We're nerds.
absolutely. And I just want to, for those of you, civil procedure students, what the conversation Laura and I were having about Rule 15A, you'll recognize from the discussion of the amendment rule, but Laura's talking about the idea of prejudice. Prejudice, I think, in a sense of, and that John adverted to as well, um, uh, by the fact that as the defendant, but I've been litigating here against the plaintiff. I've expended time and resources and so on. Uh, I'm prejudiced by the fact that I now have to, if the amendment is allowed, go to state court, or I would say at the very least I have a strong claim of prejudice. John, anything you would like to add to what we've discussed so far? This is kind of closing statement time.
I feel like I've overspoken my time allotment. I would just say I look forward to diversity rules being cleaned up. Uh, I don't think there's a loser if you are remanded, right? You go to state court and you litigate. And if I can even say, I'm going to give a little nod to claim and issue preclusion. Let's say I see issue preclusion. It's sort of like let's transplant the parts that are already litigated. I mean, you can still have a certain efficiency. So now you go to state court. They're perfectly, I don't share the federal bias. I've never shared the federal bias. And so it's nothing tragic. I even question prejudice. So those are my final remarks. I'm so glad. Let me just thank you, Dean Citron, for inviting me to this conversation.
Ditto.
Thank
It was a
you.
lot of fun. Yeah. Really.
Yeah. No, I will take 30 seconds, or if you talk to my students, that means 2 minutes. To thank you both, of course, for joining me for the podcast and for being such enthusiastic discussants. Um, I do think, however much, the way in which the the way in which the opinion was written, sort of opens up questions or gives us things to look out for, as some of which we flagged. Um, I do think that the first part of the decision, the primer part, will be invaluable, will be invaluable to students because, of course, there's a discussion of original subject matter jurisdiction, there's a discussion of supplemental jurisdiction, there's a discussion of removal, and you know, if for nothing else, I think the opinion has great value to us and to students in the civil procedure course. On that note, let's conclude, and thank you again so much.
And thanks to the law review.
Thank you so much for hosting us.